Good morning, everyone, and happy Wednesday. Thank you for joining us today. We know it's busy this time of year. Some of you have recently completed fall break. Some of you may have a late fall break, and obviously, we're transitioning into the second 8 weeks of the semester. Uh, Today, we are honored to have a special guest here with us, and I'd like to introduce our speaker this morning, Miss Tawanda Foster Artis. She is currently serving as our general counsel here at the system office. Prior to arriving at the system office, she served as a senior staff attorney for the North Carolina General Assembly. She also has experience in our North Carolina Administrative Office of the Courts, as well as the Department of Justice. Uh, when thinking of sessions and questions surrounding student life, there are a number of sort of ongoing questions that may fall into the legal realm. So we wanted to put together an opportunity for you all to ask questions. We did pose some questions to her already as it relates to some obviously COVID and things of that nature. And so what we'll do is I'll pause for a moment to see if she wants to give any sort of opening statement or opening remarks, and then I'll read uh, one of the some. We'll go through some of the questions that we have, and then if you have questions along the way, we ask you to chime in as well. Fair enough. All right. So Miss Art.
Good morning, everyone. I'm really happy to join you today. Was very grateful for the invitation from Dr. Evans. Um, I've been at the system office now since about April. And so, because of COVID and because we are in such a virtual world, I don't have a lot of opportunity to meet people on the campuses. So, I'm really excited about this opportunity to connect with you all, to offer any information I can, and to be a resource for you in any way that I can. So, I hope that this will extend beyond our conversation today, and you will feel free to contact me anytime you need help.
So we'll obviously ask a heavy question first and just get it out of the way. So one of the questions that we asked was, can or should an institution require proof of vaccination in order to travel with students to an overnight conference, event, activity, etc.? And so take it away.
So I'll start a response to this question by talking about my time at the legislature a little bit. So my disclaimer when I was at the legislature was I don't make the law, just write it down. And that would be, people would come to me and complain, oh, you need to get your people together. They did this and they did that. And I would say, I don't write the law. I don't make the law, just write it down for them. And so when you ask a question like can or should, I can tell you what the law is. That's what I can do as a lawyer. Should you do it or not is public policy. And so that is where each institution will have to make their own decision. So that's I can't tell you what you should do, but I can tell you what the law permits. So the law does permit an institution to require proof of vaccination for any purpose that they choose, whether that's to attend classes, to attend an overnight conference. Institutions can do that. Um, Whether or not you should do that gets into a whole host of other concerns that each institution will have to weigh for themselves. Things like, do we feel that we're wading into things like medical exceptions, things like religious exceptions? Are you going to get a whole host of information or background information about your students that you may not want and may not want to be responsible for should you make a decision like this? Because if, let's say, you require proof of vaccination and someone says, hey, I have a medical exception, I have cancer right now, I'm receiving chemotherapy, my doctor has recommended I don't get it. And you require some proof of that. Now you're holding private medical information from a student, and you're going to be responsible for all the federal statutes that go along with it. And so when you're making that decision, just think about down the line all the other consequences of how you store that information, how you make sure you're protecting it in compliance with federal and state law. So yes, you can. Whether or not you should is a whole different ballpark that I cannot answer for you.
As a follow-up question to that, who should be included in that conversation at a local college to ensure that all bases are covered?
Let me go back because I should have said one other thing for your initial inquiry. Um, so the other piece of that, if it's conference related, you have to also think about what the conference stipulations are. And so that's something else we're seeing in the community college context, right? Where it may not be our vaccination mandate, but there's some ancillary group or organization or facility that has a vaccination mandate, and how that interplays. So I would suggest that one, you always check with your facilities, with your conference providers, those types of things, and be aware of what their policy is. So it's not just the school's policy, but theirs as well, in managing how your students participate. Um, as well, you could always be mindful of CDC guidance and governor's executive orders as well, especially if you're traveling to another state or another locale that may have different rules than where your local college is. So now to your question, Dr. Evans, about who should be involved in the conversation. I think this is a conversation that goes honestly from really all levels of the faculty, from the president as the chief decision maker and the person who's responsible to your local board, to you all as student services and student affairs professionals, the first line of help and resources for the students, to the instructors, because they're going to be impacted as well when they're in the classroom with these students. And unfortunately, that's where a lot of the issues kind of come to the surface, even if students haven't sought you out as student services professionals. There's some breakdown or issue in the classroom. The teacher's going to have to deal with it in that moment and then try to bring in the resources that are needed. So I really think it's a conversation that should be had at all levels and that everyone should be involved in. Ultimately, I know the president and the senior team will probably make the ultimate determination. And of course, you'll probably have to have your local board approval, but I do think everyone should be involved in the conversation.
I'm going to pause here to see if there are any questions from our audience as it relates to our first prompt. Anyone want to chime in, throw their question in the chat, or unmute themselves? All right, hearing none. The second question deals with travel as well, just sort of in a different aspect. And so the prompt was, what type of liability does an institution have if they allow students to drive their own vehicles to a college event or conference instead of riding in the official school vehicle? What process should institutions use to ensure that they are covered?
So I want to take that question in a little bit different order than you said it. Let's start with riding in the official school van or vehicle. So I'm sure you're mostly familiar with all your liability around that. Same as if you were a private driver in your private vehicle, you know, the duty of care, the duty not to be negligent or careless or reckless in how you operate the vehicle, the things that are provided, as well as CDC guidelines for public, air quotes, public transportation or congregate transportation anyway. Does include masking, so making sure if you're going to put students in a van that there are masks, and that if they don't have masks available that you provide them for them to comply with CDC requirements. As far as driving their own vehicle, I don't think there's a way to prevent a student from driving their own vehicle if they want to, especially if they're an adult and they say, you know, I want to participate in this, but I want to drive my own vehicle. I don't know how you would stop them. As far as liability for them driving their own vehicles, I do not believe you have any. As long as you didn't require them to drive their own vehicle. You know, if let's say Dr. Evans says we're taking this trip to XYZ conference, there's going to be a van leaving at this time, and student A says, well, I don't want to ride the van. I don't want to be around other people, or I have to work late, and so I'm going to leave at a different time. I can't comply with that time, so I want to drive myself. They're operating their personal vehicle, their personal time. It's in no way, you didn't require them to do so. So you don't have any liability for that. I think the conversation may be different if they're driving your vehicle or you as a faculty member decide to drive your vehicle and have a student ride with you. I would suggest that would not be a good course of action, because then you have all the standard liability for any that you would with any passenger in your vehicle. Should you have an accident, should that person be injured or unfortunately killed, then you are open to all the same liability. So school van, great option. But if a student wants to drive themselves, I don't think you can stop them, and I don't think you're liable.
JJ, I have a follow-up question to that.
Jump in.
Okay, so if the student decides they are going to drive their own vehicle and not ride in the school vehicle that is provided, do we have to provide them with mileage reimbursement?
I don't believe you do, but this is a very interesting question. And so what I will say is maybe we have to research it, because I know there was some recent statement about SGA presidents being quote unquote employees of colleges because of them receiving some reimbursement. And so that's why I think this is a very interesting question. I think, Dr. Evans, you and I discussed that SGA president thing, and that's shocking for me. And I don't really fully understand why the federal government fell in that area. And so I do not believe you're required to pay them any kind of reimbursement, because they are not your employee. However, I would also argue an SGA president was not your employee, and the federal government is clearly in a different place on that. So if you would like me to research that and get back to you, I'm happy to do so. I'm making a note right now of that. Okay.
So the next question we sent as a prompt was in relation to early and middle college students being transported. And so the question we wrote, which was, now that I think about it, maybe a little unique, but can early and middle college students, or students who are considered minors, I guess younger than 16, travel in 15 passenger vans or vehicles? Should that be the college vehicle of the only college vehicle option?
So there's no prohibition in the law from transporting students of any age in a 15 passenger van. I think the places that you'd have to comply with the law is, one, having permission from parents to transport their children. I would suggest that permission be in writing for a specified term, period of time, X dates from X dates, and signed by the parent or legal guardian, as well as proper seatbelt usage based on the child's age. Other than that, I don't think there's any prohibition that keeps you from transporting students. And then, of course, in compliance with CDC guidelines as well, whether that's masking or whatever is required based on COVID.
Now, we often, so sort of a follow-up question, we often hear that, waivers or travel forms aren't really, won't really, I guess, hold up in court in terms of releasing the college from liability. Yet you just indicated that, we have to get parents to sign documentation and information. And so how do you bridge that gap?
So two things. One, when we talk about parent permission to travel, the one reason that I think that's really important is a student runs away while they're on a school trip or school function, and the parent says, well, I didn't even know they were going. Well, you signed this form that said you did. So that resolves and protects you in some ways from liability. Second, as far as waivers, your question about waivers and whether or not they hold up. So let's say there's a school function with a school van and there's an accident, and unfortunately some students are killed or seriously injured. So a waiver will not absolve you of all responsibility. What the court will look at will be duty of care. Was there a reasonable duty of care? Was everybody properly buckled in? Was the van not over capacity? Was the driver driving carefully? You know, who's at fault for the accident? Did the driver fall asleep? Was the driver drunk? Was the driver, in the wrong lane? Those type of things, no waiver is ever going to save you if there was not a proper duty of care, caution, or if that person was in some way negligent. So that's what the courts would really look at in making that determination. So a waiver won't save you, but it does help you for things like, let's say a child falls in the van and breaks their arm. Okay, well, you knew they were riding in the van. We were trying to take all precautions. The van was stopped. We weren't moving. The child wasn't just walking around while the van was in motion. It was an accident. So I look at waivers for more simple accident type things as opposed to major injuries, death, or something where someone may have been negligent.
Any questions about that? Any prompts from the audience? All right. Hearing none. The next question also deals with traveling with our younger students, and that is, should the college or should the student life professional require a member of the early college or middle college staff to travel with the delegation if they have a significant amount of those students going on a particular trip or conference?
Again, there's no requirement in the law that it has to be that staff member. Should they? I think considerations, I don't know how many people on the call are parents, but if you're a parent, then young kids are different than older kids, and a lot happens in those teenage years. And so just from a consideration and weighing the factors point of view, I think it would be good to have a staff member from the middle colleges or early college program, because this is someone who knows those students, who knows the students' personalities, knows the dispositions, knows kind of the issues that they may be facing. And what we all know about teenagers is they may not be the most open or talkative or ask for help. And so I definitely think if there's an issue, you want people that they are comfortable with around, that they know, as opposed to faculty or staff that they may not know. I don't think we can expect a 14 or 15-year-old to ask for help from someone they view a stranger in the same way we might expect a 19 or 20-year-old.
Our next question gets to how do we handle room assignments when traveling, and how do you do that if a student may be transgendered? So how do you accommodate that student? Do you pair them? How do you conduct roommate pairings? Does that dynamic change if one student's a minor or one student is over or considered a legal adult? And really help us talk through that issue.
So a few things. This is a really difficult issue. I was smiling as you were reading the question because I knew that this one was coming, and it's a hard issue. I'm sure it's hard for you all, being that first line resource as well. So the short answer from an education law perspective would be, if your school has a housing policy, you follow the housing policy. Because we're community college level, most of us will not have any kind of housing policy. So we can't rely on that. Most institutions, based on my research, do assign rooms based on gender from birth, unless there has been a gender reassignment surgery, which again gets into that gray area of how much information do you really want about your students? Do you really want to be asking them if they've had a gender reassignment surgery? And if so, how do you protect that information? Because that is private medical information. I I would suggest that if you have to go to getting information like that, you do that maybe through your special accommodations office, because they're accustomed to receiving some medical information from students. My thought would be, where possible, you do provide single room options if there may be some discomfort, either for the transgender student or someone else who may be paired with the student. Then you should be prepared to have some single room options, so that people don't have to share a room, share a bathroom if they are uncomfortable with such. As far as your question about age and students of similar age, I would always recommend that you keep students, if you're going to assign rooms, students of the same age together, and not pair a younger student with an adult. I think that opens a can of worms that could potentially open you up to liability should something happen to that child in that room. We know that for statutory rape statutes in North Carolina, mistake of age is not a defense. Just by virtue of the fact that there was a sexual act between an adult and an underage person, that would be statutory rape, consent or not. And so, or confusion or lies about age or not. So to not open that door for any of your students to be harmed or for liability for the college, I would suggest that you always keep kids the same age together. I saw a hand, I think, Dr. Evans.
Gilbert, go ahead. I see your hand.
Yeah. Thank you, Dr. Evans. So my question is, what if you have a male and a female student who are going to conference with you, boyfriend, girlfriend, not legally married, and they want a room together? Is there any rule or anything that prohibits them from being able to room to, because typically, and I know most of the advisors on here will agree or hopefully agree, we typically put male students with male students in a hotel room, female with female. But, I recently had someone say to me, if I do a trip and I have a male and a female student and they want a room together, I can't prohibit them from rooming together. And I disagree with that, and I have issue with that. But I guess my question is, what does the law say about that?
So I think that question goes back to definitely age, number one. So if you've got an underage student, these are underage students we're talking about, then I think you absolutely can make that determination and say, we're keeping this room assignments based on gender. As far as adult students, people who are clearly grown, 20, 21, 22-year-old and up, I think that you can have the policy and require them that if that's what they want to do, then they do that on their own, independent of the trip, independent of the host hotel, or, that we're not booking a room for you to stay with your boyfriend or girlfriend. If you want to do that, we can't stop you because you're an adult, but we won't be a party to it, I think would be the safest way to handle that.
What if they happen to be married?
Now, if they're married, I think that's a whole different ballpark. I think we all know how marriages are consummated. And so if you're married and, you're in a legally consummated marriage, I don't think anybody can stop you from staying with your spouse. And maybe requiring proof that they are married.
That was going to be my question. Do we need to ask them to provide a marriage license? And because I'll give you an example of a situation I had. I had a out-of-town trip. It was my fall break trip to Washington, D.C. And I had a female student come to me who wanted to room with a male student, but they were mother and son. And so I'm sitting here going like, okay, how do I deal with this situation? So I asked her to provide me a copy of his birth certificate showing her name listed as his mother and him being the child. She did with no problems, and that took care of it. And I let them room together on the trip because they were mother and son. But I did ask them for proof. So
was the son okay with rooming?
Yeah. Oh yeah, he was fine with rooming with his mom. Yeah, because it was a room with 2 double beds, so they each had their own bed, but they wanted to room together because they were both going on the trip and they didn't know anybody else going on the trip. So
okay. I think that's fair. And I think if you have a unique situation like that, requiring some documentation is needed, because what if let's just say that's not the case. What if that's a lie? What if this male student is being sexually trafficked and this is his abuser and he doesn't feel able to stand up for himself? At least by requiring some proof, you've required what you can under the law to try to make sure your student is still safe.
Any other questions as it relates to traveling with students or some of these gray areas while we have a moment? All right, so hearing none, I think the question that came up before that you briefly touched on was, in many cases, colleges are now viewing student government positions, student leadership positions, as that they are employees and or working for the college, and therefore they should be compensated instead of via stipend or scholarship as a paid employee, in which, you know, if you're counting time or counting hours, that means they're submitting a timesheet and therefore have to go through some semblance of an HR process to be included as an employee at the college. Can you talk a little bit about sort of your perspective on how colleges should address that issue, or you know, if your college is paying students not through the HR process, like what will need to happen to sort of transition to being in compliance?
So a few things. I think it's clear that I don't necessarily agree with the law in this regard, but we do have to follow the law as long as it is effective. So I would certainly encourage your HR department to come up with some process for how you hold those records, you know, what the requirements are for reimbursement, how that's divided up. You know, if your SGA president normally got a $500 stipend for the whole year and you're used to just writing one check, then how you break that up. Do you do it monthly? Do you do it weekly? And whatever you do, I'd encourage there to be a policy around it. And I would encourage HR to hold those records, mostly because HR is accustomed to managing private employee records in a way that student affairs may not when it comes to the employment context. So I would certainly ask for help from your HR department. If you have an attorney that represents your college and board, I would loop that attorney in as well to make sure that HR is following all the necessary IRS guidelines and has all the proper documentation if needed. I don't know whether our compliance audit folks have looked at this or not yet, and whether or not this will at some point become a part of the compliance audits. But I would encourage you to, whatever you do, have a policy around it so that if it does, you can show that you are in compliance with the law. Anita, I see your question in the chat, and my understanding was that it was only the president of SGA, but what's your recollection, Dr. Evans? And I can search my email real quick from when we were talking about this.
Right. So this question came up from one of our colleges, and it's because their institution is now requiring any student leader that is currently being compensated via stipend or some other type of payment to now be considered a paid employee by the college, because they have work requirements, they have hours that they track, etc. And so they view that as a paraprofessional or a pseudo employee of the institution, and therefore they have asked to transition all students from this stipend or scholarship model to being a paid employee in some manner. And so the reason why I sort of brought this, Ms. Artis mentioned it earlier, so I wanted to again have this conversation, because I know that there are colleges that, you know, are either paying their student leaders via scholarship, and that could be a tuition scholarship or monthly or at the end of the semester. I know that there are some colleges that are paying students via stipend, but that's, maybe a check at the end of the semester or, once all work is completed. But I can only name maybe one or two that are now paying their students through the official employee capacity, whether it be monthly or bi-monthly, depending on how your institution pays its employees. And so I think the greatest concern is that this may become a larger issue. And if your institution isn't currently looking at this issue, or if you haven't had conversations with your local HR professionals, business office, et cetera, to potentially bring this up as a topic of conversation to figure out how the institution should move forward.
So I was trying to look it up while we were talking, and I'm not finding our original emails about it. So maybe we talked about this in person. But there are a number of issues that I monitor. Once I know that there are issues, I just try to keep them on the front of mind and research. And I'm a part of an organization called the National Association for College and University Attorneys. And we have these periodic roundtables where we get together as general counsels and talk about the legal issues we're seeing across higher ed. So this is one that has come up and that I'm monitoring, because I wonder if this is a fluid moment in the law and we'll continue to see it change. So I'm happy to circle back if we do, or issue a numbered memo if something changes, and it would be helpful. But I think until we kind of get into a more settled point in the law, maybe the next 6 months to a year, we continue to follow it and see how it goes.
Thank you for sharing, Beverly. I didn't want to name the institution specifically, but the question
You can
was,
always call me out. You can.
I didn't name the institution.
It's complicated, so complicated, because our students are coming in and out all semester, and they gave my students a deadline of September 22nd to have all their HR paperwork completed, but we were still onboarding. And so I was like, what is going on? We can't do that. So I'm working on a scholarship like simultaneously so that we can get that scholarship ready to apply. So, and I'm changing all the language and everything that I'm using, and I'm sending it forward to be approved through our business services side, because this is too much. I mean, for our students, and then some of them are work study students, so there were conflicts, and then others didn't have their social security numbers yet, so that became even more involved. It was so many pieces I was not prepared for. So by December, we're gonna have some checks for these students somehow, some way, and we're gonna be legal.
Beverly, when you get that figured out, will you share that with the rest of us that are still paying every other couple months or whatever we're doing?
Goodness. Absolutely. Is that Barry Cross?
Yes.
Yes, absolutely. I know your voice.
So again, the greater conversation is understand how you are paying and compensating your students. And then I think most importantly is have a conversation with your business office, your VPs, to figure out what that process should be, and ensure that it's within compliance is probably the greatest thing that we can suggest at this time, because obviously there's some confusion or trying to figure out how you do that within the law and the framework that we have currently given.
Yeah, and I continued looking, and what it basically says is that the Internal Revenue Code defines an employee as an individual who performs services that are included under an agreement or entered pursuant to Section 218 of the Social Security Act. And so I think that's why they're deeming these people employees, because they are completing some work or performing some service, and they're considering the stipend to be payment. And so it's interesting. It's an interesting issue. And Beverly, I really do wonder if you transition to scholarships, if that would alleviate the burden. I think it might. But I'll continue to follow up and circle back if I feel like I can offer something better.
Thank you so much. And I'm praying it will. It might not. I'll let you all know.
Are there any other questions or any other prompts while we have Miss Artis here? That ran through our list. So if there's a burning question that you all may have, feel free to chime in. And so we'll pause a minute for you to do so.
Tonda put an interesting note in that the scholarships could be used to pay off student debt, and they may not receive it. And while that may be an unintended consequence, I don't think that it changes the legal ramifications of if we change this to a scholarship and not a stipend, if it gets you around counting your leadership, your student leadership as employees. I think it still does. I just think that may be an unintended consequence that students may not be entirely happy about.
I'll ask another question just because it's going to be, oh, sorry, Gil, go ahead.
No, you go ahead. You go first. I'll go after you.
So it's going to be political season again. And I know that many college campuses came under fire for their rules and regulations regarding free speech and, bringing, views from across the political spectrum on their campus, or being denied, certain parties or views may being denied. Can you talk a little bit about free speech and sort of how do you navigate the heated political spectrum in which we will be in shortly again?
So I think the basic rule around free speech is your right to speak freely ends where it incites violence or it incites some negative or I want to word less than violence, but under the law, we call it quote unquote fighting words, something that will spark an elevation of conflict, So I think being mindful of that, that it's not just carte blanche. Anybody can say anything they want to say whenever they want to say it. That's not what the law allows. Yes, you can speak freely, and colleges should be a place of discourse, right? They should be a place where different ideas are examined and discussed and debated, but that we remain doing so respectfully. And I think not only focusing on what the law allows with that, but also what your student code allows, and whether or not the commentary, the conversation, the behavior that results from whatever that free speech moment is in any way violation of your student code or the type of behavior that you would want from your students.
Jump in, Gilbert.
Okay, so I have a question, and I don't know, and I might need to meet with you separately about this. I recently had a situation where a campus club, the advisor basically stepped down from the club due to the fact that he had a lot of stuff going on because we were working on our 5-year plan and all this kind of stuff. And the club that he was over, the students were not keeping the advisor in the loop on what they were working on, what they were taking care of, and when they were. And granted, students are allowed to meet without advisors. They can talk and work on things, but then when there's an official club meeting, the advisor should be present to assist the club, answer any questions and whatnot. And he wasn't even getting feedback on what they were working on outside of the club. So this particular student reached out to the Foundation for Individual Rights in Education, better known as FIRE. FIRE reviewed our online student advisors, clubs, and organizations handbook, and basically told us that we were infringing upon the First Amendment rights of our students by saying that an advisor had to be present for official business meetings and whatnot. They also said to us that in my role as the student life person, that I could not sign off on things and approve things for campus clubs and organizations, like, you know, things that they were trying to do that they were supposed to get permission from me on. So I guess what kind of language do I need? Because we're going to need to rewrite some of this so that it doesn't look like, you know, we're infringing upon students' First Amendment rights. But do you have any suggestions or recommendations on language that would not make it look like or sound like we're infringing upon students' First Amendment rights by saying an advisor must be present at officially, you know, sanctioned business meetings of a campus club or organization?
So I disagree with the letter you received from Fire.
I'm glad.
Just from a legal standpoint, I think you have the right to require a student advisor, faculty member, or somebody to be present, because again, let's look at the liability issue. If something were to happen, then the school would be liable. So you need to have your staff, your boots on the ground person, at least in the loop and knowing what's going on. I agree and understand that students may be meeting informally and doing things without an advisor, but I personally don't see a problem with your policy. I'd be happy to review the communication you received from Fire, and give you some more advice about it offline if you'd like.
All right. That would be great.
But I actually don't agree that there's any infringement. We could talk more in detail.
All right, I'll get with you. I'll schedule an appointment to meet with you. So.
Please do.
All right.
And just a quick aside, I think Fire came through a 1 or 2 years ago, and they did some like large scale assessment of all the higher education institutions in North Carolina. Like they looked at their free speech zone policies. They looked at like student handbook code of conduct type issues. And then they were sending letters to institutions saying that they were out of compliance in these particular areas and that they could be subject to, litigation or, some future action should it come down to it. But I think that, I think that sort of sprung up again when we get in political season and sort of dies down when we're not in a major election. So it's interesting that that issue came up for you, Gilbert.
Well, and I think what the issue boiled down to is the student was ticked off that the advisor stepped down, and that I told her in order for them to continue to meet and be an officially recognized club on this campus, they had to have an advisor, and they couldn't find anybody to be the advisor. And so I don't know. And the organization, the club that we had is NCPIRG, another group that, is very political and wants to, get people registered to vote and all. And I think it's well worth it. But I think NCPIRG's person went to this student and said, you need to contact Fire because the college's policies and what they have written up is infringing upon you all as students, your First Amendment rights. So.
Yeah, and I think students have the right to gather and have these informal conversations and to develop their own plans. But what they don't have the right to do is do it on a college campus,
right?
Without some college oversight. Now, if 10 students gathered on campus and said, we want to go talk about XYZ and we're going to go down to the local McDonald's and do that.
Yep.
By all means.
We're fine with that, and we encourage that. We're like, y'all need to be working on stuff outside the regular meetings. So when we get to the business meetings, regular meeting, y'all got stuff we can take action on and make it happen. Y'all need to be doing the work outside of these meetings. But when we come to the business meeting, be prepared to, okay, this is what we've been working on. This is what we want to do. All right, let's make it happen,
So we have a number of questions in the chat. And so we'll jump to the first one from Ms. Lewis. There have been many conversations regarding gift cards, giveaways, and meal cards. Our college is given direction, but we are continuing to figure out how the IRS deems this as payment to students and how we should report it. We are required to have a handwritten signature for all gift cards, or at least make a reasonable effort to capture a signature in addition to a name and student ID number. The question is what all accounts for a payment or funds given to a student for a non-emergency. And so, for example, if a student comes to the institution, says the institution gives gas cards as a way to help a student in need, how should they document that the student has actually received it, and the college employee is not, putting it in their pocket, whatever the case may be. And then the same thing could be, if we're raffling off a gift, say a $500 gift card to the winner of X drawing, sort of what documentation or what ways can we ensure that, the transaction there's documentation of the transaction, and the student actually received the gift or received what they needed.
So Beverly, the first part of your question, I don't know. I would have to look in the Internal Revenue Code and look for a definition of payment, which I'll try to do in just a moment, in hopes that I can find one for you. As far as documentation, I would suggest that you do just exactly what Dr. Evans is talking about. If you give away those items, that you are keeping some kind of list of what the item was, what the value of the item was, and who received it. I think about this in the context a lot of fundraising and auctions. And a lot of times, like, let's say you have a fundraiser that's an auction, and United Airlines comes in and gives away a $200 airline voucher. The person who received that voucher in your auction, if they do not pay the value of it, would be liable for taxes on it as an enrichment, a benefit, a payment. So I think maybe the IRS could be looking at this in a similar regard. So I would suggest, until you have a clear answer whether or not those are reportable things, that you do have a record, should you need to report them. And while we're talking, Beverly, I'll look for a definition and see if I can come up with one for payment.
Yeah, and there's a related question, because if they win Amazon gift cards, do they need a W-9, or does language matter in terms of it being called a raffle versus auction versus drawing versus etc.? And so I think there's probably a lot of questions that sort of surrounds this particular issue.
I think you're right, and I do think I think what the biggest thing that matters is whether or not the student gave anything of value to get that item. With a raffle, usually, you're buying the $1, $2 raffle ticket, so maybe you gave something of value. Same issue with the auction example I gave. If it's an auction where you're bidding something to win it, then maybe you gave some form of value versus a random drawing or just something that is need-based. And I'm just looking real quick to see if I can find anything that defines what a payment means. I'll take some time and okay, so one thing that I found is what's a taxable gift? And it says the term taxable gift means the total amount of gifts made during the calendar year, less deductions. So that would be what you report, but it does not say whether or not the student would have to pay taxes on that, and whether or not you, and how you would report that. I'll do some research, Beverly, and get back to you, because I don't want to hold everybody up.
Thank you.
So Jesse, I see your hand up. Well, we're going to talk. Go ahead and chime in, and then we'll jump to the music license question. Don't forget to unmute yourself.
Sorry, I'm so sorry. My question is about campus ministry groups, and I don't know if you covered this in the first 15 minutes because I had a previous meeting, so I missed the first 15. But currently, we allow campus ministry groups to be formed by external organizations, so churches, as opposed to students starting a club or organization. They do register through our student engagement department. We say these groups are not supported by a college or state funds. However, we allow them to reserve space in buildings to meet. Currently, I have a church that has requested to form a campus ministry on our campus. They gave me their website, which when I visited, one of the first things mentioned on their site is that marriage is between a man and a woman. I feel like this language is not inclusive of all of our students that attend our campuses. So when these groups come, I almost feel like it's to solicit members to their churches. You know, they're looking for new church members because this isn't students that start these clubs or organizations. So what is the difference between having them register as a campus ministry being externally affiliated versus why not use the free speech space on our campus? Just because while we haven't had a problem, what if a student goes to that meeting, does not feel welcomed, is told things that goes against who they are as a person? How do I protect those students? And am I even required to allow these external organizations to gather on our campuses as a ministry? I understand I feel like they'd be better off being in the free speech zone as opposed to being a campus ministry. What are your thoughts, or what is what's the law that's on our side, or what am I required to do?
So, Jesse, I think you've kind of narrowed the issue for yourself. And I think this is one of those gray policy questions where you have the right to set whatever policy you think is best and best protects your students. And so if that is that these organizations are not allowed to be officially student organizations, or whether, like you said, they're limited to your free speech zone for meetings, whether you require, a certain number of students to join before they can become a student organization. I think you as a college campus leaders can set whatever policy you think best protects your students on this. The only thing I would say from a legal standpoint is whatever your policy is, you have to apply it across the board the exact same. So if these groups can't come on campus and start ministries and be recognized as a student organization, then no other third party should be able to do so as well. If there's a requirement of how many students need to participate, or if it's student generated, then I think the legal issue is only whether or not it's applied across the board the same. And I guess the question becomes, I would imagine there are a number of organizations on campus that people could choose to be offended by, should they choose, right? If it's I don't know if your colleges have this. In the university context, we always had young Republicans, young Democrats, and people would affiliate by their political affiliation and have a club around it. Somebody could easily be offended by that and not subscribe to those policies, but is that a reason not to have that as an organization on your campus? I think that's a decision you have to make for what's best for your students. I think the only legal standpoint would be just apply it across the board evenly.
Thank you.
This next question often comes up a lot and is from Lynn Watts at Davidson Davy. Can we talk about responsibility in terms of music licensing fees? Do we have to have more than one? We are currently being asked to pay 3 through the three organizations, SESAC, BMI, and ASCAP. There seems to be a lot for Medium College, and usually this happens when colleges have like athletic programs and or are playing music at those types of events, or they may be playing music in other avenues or venues at the college where they're being required to they're receiving these notices of you're using license you should be paying for this music license in order to play this music on your campus.
Oh, this is very interesting. I had no idea that this was actually a thing. For student life events that you were being asked to pay licensing fees. Um, I don't know that you should be paying three different parties. I would think that if you do have to pay music licensing fees, you pay whoever holds the ownership in the music. So it's interesting that you're being asked to pay from three different entities. And so I would encourage you to find out who actually owns the music and pay that one party if you're going to pay.
So you have to pay the composers, you have to pay the writers, and then I'm not sure what BMI actually does, but ASCAP and CSAC are for the writers and the composers of the music. And so it's three different organizations that you have to pay into. My question to everybody else on here is anybody else being hit up by Global Music something or another? Because we're getting I'm getting emails and they keep saying it's Guildford Technical Community College, and I'm like, dude, if you can't even spell our school right, I am not paying you any money. But he's, you know, his email is Bruno Mars joined us, and Jay-Z, or I can't even remember. There were like, you know, super popular people, and we own the rights to their music. So if you're playing their music, you owe us money. And I totally ignored him, mostly because he misspelled Guilford Tech, and I feel that I'm justified in not paying him because he can't spell our school name right.
So,
But
Ms. Cross or Ms. Watts, if you had anyone that has received any of these letters, please send them to me. And what I'll do is I'll compile them all and share them with Ms. Foster Artist here, and then we'll do some digging on that issue, just because I know that they seem to find you every year, especially at the beginning of the year when, you know, they want you to pay this renewed licensing fee.
And I will tell you, Lynn, I'm shocked to hear this, so I'm happy to. I probably won't be able to do it myself, but I will ask one of our attorneys in our office to look into this issue a little bit more, because I think we should probably have a standard policy on how we handle this, because I don't know how much you're paying these people, but I'm concerned that you're paying anybody anything for just playing music on campus.
it's based on your FTE.
And
We're happy
again,
to look into it.
it usually falls to the institutions that have NJCAA athletics, because, you know, they're more than likely playing music at events or things of that nature as teams warm up or whatever the case may be, and less so about like playing music in your bookstore or at an event on campus where you just want to have some music while you're outside at a festival type thing.
We were told we had to do it for that too. In our cafe, in our bookstore, in our coffee shop, and if I'm playing it for an event.
Okay.
If I'm playing it anywhere on campus, we were told we had to pay a licensing fee.
And it may not be coming out of student life budget. It may be coming out of instruction, or it may be coming out of some other institutional funds, which could be why some of the student life people that are on here now are not paying it out of their budget. It may come out of some other budget.
And to my understanding, it doesn't matter what the source is either. So you could be playing it from Spotify, you could be playing it from the radio. It doesn't matter. You would still have to pay the licensing fee. And I saw somebody say, what if we hire a DJ? I don't know about the DJ thing, but I know from working in bars, there are lots of issues around DJs and playing music that isn't original music that the artist is actually playing in your bar. So I would assume there's probably questions around a DJ on your campus too.
Is anyone comfortable telling me how much you're paying in these licensing fees?
I actually don't know, because it doesn't come out of my budget. Well, it comes out of my budget, but it happens before I even get my money. So I'm not really sure.
This
So
is
Guilford,
Barbara Cabarrus. It's about $350 a year.
Okay.
wow. Well, so at Guilford Tech, we pay a couple thousand. We pay probably 5,000 a year based on your FTE.
And that's all of them total, or?
Yes,
Okay.
I think. I'd have to go back and look, but yes, I think that's what it is.
Yeah, please, anyone that's receiving any of these music licensing letters or emails, please forward them to me or to us, and we'll try to get to the bottom of it for you. We're coming right up on the hour. Is there any last minute questions that anyone would like to pose, or any topic of discussion that we need to do some further research on that we want to take a few minutes to discuss? Any other burning questions?
JJ, I have one, and I probably shouldn't ask it. And I wish I could mask my voice so you didn't
Well,
know
then
it was me or something.
that means you should ask.
It has to do with N4CSGA. Can I still talk about it? Okay.
Yes, you can still ask the question.
So, it's a shame that this organization isn't fluid the way it could be. And I wish, in all of my wishes, that we could have something done where somebody could be hired to manage that organization. As I work more and more closely with PTK, I'm finding that people who have a job and a role and they're compensated for it, that is apart from their, 9 to 5, 8 to 6, in our case, 8 to 7, they can give a lot more to the organization, and the organization, it thrives. And I feel like we're shortchanging our students across the state every year because it's not thriving the way it could, because it pulls from all of us. And we really have barely enough time to do the work we're doing on our campuses. We all desire for it to do better. But I wish there was some way that the fees and the things that we poured into it, somehow we could figure out some type of magic to make it work, to hire somebody or to compensate somebody.
At what level, Beverly, are you suggesting someone work? Would this be somebody on a college campus? Are you suggesting someone at the system office?
Any way possible. I think put everything out there. We've talked about, I don't even know if the system office would be willing to have somebody housed there that handled that. That's what they do. Or because I think if you house it at one of the institutions, you'll end up with the same issue yet again.
Okay.
And so I think part of this issue goes back to, as a 501c3 organization, the leadership of our organization is all voluntary. And so shout out to Tiff for serving as our advisor for our organization for this year. And so, right now, institutions are paying an annual membership fee into our organization, and then of course monies for conferences and things of that nature when we house those. And so how do you have a third party entity that is sort of separate from the system office? It's almost like the trustees association, where I think Ms. Woodson is the president of the trustee association, and that's her primary role and responsibility. And that's what she's doing. Shane, I see your hand up. Chime in real quick.
No, continue. I'll get it after. It's just related to N4C.
No.
No, it's unrelated to what you're talking about.
Gotcha. So it's really, how do we ensure that our this third party entity that's similar to the Trustees and Presidents Association has consistency and moves forward as an organization when we don't necessarily have the resources to hire someone full time to run it, and that's underlying her question as well.
It's an interesting question, and it's being in the system office is interesting because of all the adjacent groups we work with: the Trustees Association, the Presidents Association, the State Foundation. There are all these ancillary groups, and most of them don't have paid staff. The Trustees Association is the only one that I'm aware of that has paid staff. And Julie Woodson and their assistant, who's part-time, Ashley Blizzard, I think. And so I don't know how much institutions pay for NC4 SGA and whether or not there's enough to even consider that in the budget, even if it were a part-time person or a seasonal position or something that we did as a contract with a college employee. as additional work for, so many hours a week. But it is a very interesting question. And I will tell you, we saw firsthand, the problem with NC, or the challenges, I will say, with N4 SGA with our last, the N4 SGA president is a student member of the State Board of Community Colleges. And our last president left, and we couldn't get another student to serve. We just got a student to serve. And he was just sworn in at the State Board meeting last week. But it took some months to do that. And it seemed like students didn't want to do it. And I wonder if part of that is because of the issue you're identifying, Beverly, of feeling like they needed more support or better support or, more guidance to buy into NC4 SGA. So it's an interesting issue, and I'm happy to bring it up at the leadership level at the system office, because it is a conversation we've been having because of needing a student board member. So no promises that I'll have any kind of solution on that, Beverly, but I'm happy to bring it up and see if I can get any feedback from our leadership team.
All right, Shane, last question, 2 minutes, go.
Okay, first I want to say I think that the issue with getting an N4C president was less about not feeling supported and more about we haven't been able to recruit students at a local level for SGA for almost 2 years, really. And so it's hard for us to push a student to the next level if we can't get them on our level. So a few years ago, an issue came up with N4C SGA. There was a student here at my institution who left our institution because we had an early college and he got into legal trouble and was labeled a sex offender, and could his parole officer or probation officer or whoever called our college president and told our college president he was not to be on our campus because he would be in violation because he'd be so close to our early college. Well, then he went to a sister institution and that did not have an early college, and that college was made aware of the situation. But then that student was brought to the N4C SGA conference, and where we have early college students. And the advisor at that institution was very familiar with N4C SGA, knew there would be early college students there. Who shoulders the liability in that situation? Would it be the institution that brought the student or N4C SGA? And should N4C SGA be asking questions about that when we register our students for conference?
Honestly, I think the student themselves first bear the responsibility. If they are on probation or parole and have some requirement not to be around students of a certain age, because that's probably how the requirement was written in his probation or parole, was, couldn't be in the same place or within so many feet of children under the age of 14, 15, whatever the rule was. So one, he bears a legal responsibility because he's the one on probation and parole. And if anyone reported him in violation, then his probation could be revoked and he would have to serve his active sentence in jail or prison. So one, he bears that responsibility. Any secondary responsibility, let's say he's a registered sex offender and comes to the N4 SGA conference and assaults a child again, or assaults a child. Then I think the institution who brought him there would be the one that is liable, because they should have known that he was a registered sex offender, either through his application process or just the conversation that had happened at that point, that he should not have been placed in a situation for which he could harm a child.
So should we be doing background checks on students that participate in SGA?
I don't know that you have to do background checks, but I would ask for some information, whether that's an application that has a checkbox that says, have you ever been convicted of a crime? If so, what, and it's plain. I would ask for some affirmative assertion from students that they're able to carry out whatever the responsibilities are. And I think you can get at that a number of ways without asking a direct question or doing a background check. Something like I said, have you ever been convicted of a crime? Is there any reason you can't be around students, from this age range? General questions that you could ask on an application that if there were a red flag, then that may be enough for you to go to your college attorney or someone else and ask, okay, this is a red flag. How would you like for us to handle it?
Okay. Thank you. You're muted, JJ.
Ladies and gentlemen, thank you for your time this morning. Ms. Foster Artist, thank you for your time, energy, wisdom, and expertise surrounding a number of issues, some that we still have to do some further research on. If you have any additional questions, if you want to have another session, if you think there are some other lingering issues or questions that are out there that we need to touch on that we didn't discuss today, please let me know. We can schedule a time where we have a follow-up session in regards to a number of these issues as we move forward, and especially as we're trying to navigate bringing students together and sort of what this post-COVID experience will be in a safe manner. As always, thank you for your time, energy, and efforts and everything that you do with our students on campus every day. Please take care and stay safe. And this recording will be sent and shared to our listserv as soon as it's finished processing. So have a great remainder of the week, y'all.
Thanks, everyone. So happy to have joined you.